Welcome to the International Law Virtual Classroom. This module deals with the liability of European Union member states for failure to implement Union law. Students open the zip file with the annexes they need for this module. The text of the module is sent to the registered students after the lecture. The proliferation of judicial organs on the international and regional level has been one characteristic of recent decades, ranging from the International Court of Justice, the International Criminal Court, the World Trade Organization's dispute settlement, the International Tribunal for the Law of the Sea, arbitration tribunals. Some were established to hear one case or a series of similar cases, others are permanent. It is now possible to identify an accepted international practice of turning to impartial third-party mechanisms as a reasonably effective way of setting differences and hold states responsible and liable for internationally wrongful acts in a manner that is reflective of the rule of law and the growth of international cooperation. All of these courts and tribunals and other organs relate in some way to international law and contribute to its development and increasing scope. Also, the evolution at the regional level in Europe is self-evident, where the creation of legal institutions go hand in hand with adjudication by the European Court of Justice. Together with a realization of this increasing spread of institutions, must come a developing sense of interest in and knowledge of the work of European courts. Many of the preliminary rulings adjudicated by the European Court of Justice relate to conflicts involving the application of union law and rights by national courts. Increasing cooperation between the European Court of Justice and national judicial bodies is taking place. This module deals with state liability for failure to implement union law in the national legal order of EU member states. Students stop the tutorial for 10 minutes and take the compulsory reading cases in this course and list them under the respective courts. So this module deals with the liability of European Union member states for failure to implement union law. The European Union member states are obliged to comply with union law as imposed by the General Good Faith Clause under Article 4, Paragraph 3 of the Treaty on European Union. Article 288 of the Treaty on the Functioning of the European Union obliges the member states to implement directives in national law. Breaches of the member states' obligation to comply with community law are established by the Court of Justice of the European Union following a procedural action by the European Commission against the EU member state. Article 258, Treaty on the Functioning of the European Union, is the basis for Commission enforcement action against member states for failures to fulfill obligations under the treaties. Article 258 is silent as to what constitutes a breach of a duty. The Court of Justice has determined that a breach can be constituted by a member state failing to implement EU legislation, mainly directives, failing to remove national legislation that is in conflict or inconsistent with EU legislation, incorrect implementation of the directive, deliberately or inadvertently, incomplete or considerably delayed implementation. For example, provisions of the French Maritime Code restricted the number of foreign workers on French vessels. But the French authorities pleaded that the national law was not being applied. The European Court of Justice ruled that France has not complied with its obligations under the European treaties. EU member states raised defenses such as force majeure for not complying with union law, but the only defense that will work is that the Commission erred on the facts or in law. The procedure of an Article 258 enforcement action of the European Commission against a member state for failure to comply with union law should be distinguished from state liability for failure to comply with union law before the national courts. There is no article in the Treaty on the Functioning of the European Union for this action. Students stop the tutorial for 30 minutes and read the two Frankovic rulings of the European Court of Justice. State liability for breaching union law is a remedy developed by the European Court of Justice based on the general obligations in Article 4, third paragraph of the Treaty on European Union and Article 288 of the Treaty on the Functioning of the European Union to comply with union law. There are possibilities for individuals to sue a member state for loss caused by a breach of union law. The state liability principle was established first in the case of Frankovic. This will also play a strong part in encouraging member states to comply with EU law obligations if they find themselves having to pay out significant damages in an increasing number of cases. A Council directive guaranteed employees a minimum level of protection under European Union law in the event of the insolvency of their employer, including guarantees of payment of unpaid wage claims. However, the Italian Republic failed to implement the directive into national Italian law. The Italian judge decided to stay the proceedings and requested a preliminary ruling. Should the Italian state be held liable for its failure that results in damages to an individual and grant him compensation because the member state failed to comply with union law, which resulted in damage or loss to that individual? The European Union directive had not been implemented by Italy in Italian law. Neither was it clear which authority in Italy was responsible for setting up a compensation agency. Nor was there any Italian law to interpret in conformity with the directive, nor any national procedural law to support an action against the Italian state for compensation. The Court of Justice clarified, in a preliminary ruling, that in the circumstances that Italy as a member state had caused damage to an individual worker caused by non-implementation of union law that granted him protection in case of bankruptcy of his employer, the Italian state would be liable to compensate any loss. The court ruled that the principle was inherent in the scheme of the treaty. Member states should make good any damage caused to individuals that was a consequence of a breach of European Union law. The claim required that the directive conferred an individual right which could be determined by the provisions of the directive itself, and that there is a link between the breach and the damage caused. The assessment of the quantum of damages, however, is for national procedural law.